المستمعين. نحن اليوم الخميس، ونهار الخميس بنتكلم يا عن الأخطاء الطبية مرة بالشهر، يا عن إصابات الانزلاق مرة بالشهر، يا عن قضايا السوشيال سيكوريتي والوركمنت كومبنسيشن، الضمان الاجتماعي والإصابات ضمن العمل. اليوم عم نتكلم عن قانون الضمان الاجتماعي والإصابات ضمن العمل. رح نحكي بطريقة سريعة عن نصائح قاضي من القضاة تبع السوشيال سيكوريتي ادمنستريشن شارك المحامي باتريك هوران فيهم. رح ننتقل على الإصابات ضمن العمل. رح نحكي عن شغلتين مش حكينا عنهم كتير قبل. أول شيء حاكمة الولاية، كنتوا عم بتقولوا كنتوا عم بتحكوا عن حاكمة الولاية
نعم.
اللي عم بريس ريليس. كمان في أو بريس كونفرنس. نعم. بدنا نحكي عن شغلة ما حكينا عنها بالماضي، هي اوردر طلعته ب 16 اكتوبر سنة الماضي بخص اللي بيلقطوا الكوفيد اون ذا جوب، وبالتحديد اللي بيلقطوا الكوفيد وهن فرونت لاين وركرز او ريسكيو وركرز. ورح نحكي عن الفرق بين اللي بيلقط كوفيد وهو فيرست ريسبوندر او فرونت لاين وركر. هل بيقدر يحصل على workman's comp؟ هل مضطر يثبت انه حصل عليها on the job، يعني بالمستشفى او بالإمرجنسي روم او بالعياده او لا؟ وشو الفرق بين هاي واللي بيلقط الكوفيد on the job، يعني عم يشتغل لشركه منا first responder او منا in the health industry؟ رح نحكي عنها بطريقة مفصلة أكتر. وبفتكر الوقت رح يسمح لنا ننتقل لموضوع تاني أو ثالث بالأحرى، واللي هو عن أغلبية الأوقات وقت بيكون عنده الإنسان إصابة ضمن العمل بتكون واضحة أيمت صارت الإصابة، بيكون وقع، بيكون وجع حمل باكس، بيقدر يقول أيمت صار معه الإصابة وكيف صارت معه الإصابة. منقارن هدول الإصابات اللي سهلة تحديدها وسهل ربطها بمكان العمل بإصابات مش كتير سهلة ربطها بس مش مستحيل ربطها، بسمون occupational diseases، يعني exposure on the job إجمالا to chemicals. بالأيام الماضية كانوا مثلا asbestos، هلأ مثلا غير نوع chemicals بتصير. بالأخص كتير منا نحن الإميجرانتس اللي بنجي من بلداننا أوقات يعني ما بنكون حاصلين على درجات كتير عالية، وبنشتغل in factories، بنشتغل on the line on the assembly line، وبنتعرض لإكسبوجر لكيميكالز موجودين on the job. رح نحكي عنها. هيدي أصعب بكتير بس مش مستحيلة. لازم نفصلها عن إصابات on the job مثل حدا حمل إباكس ووجعه ظهره on the job، هيدي أهين بكتير. هدول الثلاث أشياء اللي بدنا نحكي عنهم اليوم مع ضيفنا لليوم المحامي باتريك هوران، اللي بينضم لنا تقريبا كل نهار خميس ما عدا مرتين بالشهر، لأنه بيكون معنا المحامي جياسو بالأخطاء الطبية والمحامي هاورد رادنر بقضايا الانزلاق. Good afternoon, Attorney Patrick Horan. How are you today?
Good afternoon, Joumana. I'm doing great. How about you?
I am doing very well. Thank you so much. I introduced the three subjects. Let's start with the wise advice that you have received from an administrative law judge in Social Security. We're talking about Social Security. We're talking about people who apply for SSI or SSD and get denied. So they have to appeal. And when they appeal, they go in front of what we call an administrative law judge, an ALJ, an administrative law judge. You received some very wise advice from the administrative law judge. It is not advice that we have not heard before, but it's coming out of the judge's mouth because the judge sees a lot of these cases and so has seen things happen on a number of cases sufficient that he brought them to your attention. One of the first things, and it has a lot to do with the believability of the claimant. Do we call a Social Security a claimant?
Yes, they're a claimant, and the believability or the credibility determination is probably the most important thing that the judge has to do in a hearing.
Right. They have to look at that person, at the claimant, and determine whether they are as injured, whether they are injured, whether they are as injured as they claim they are, whether they are as unable to do as they claim they are, and so forth and so on. So the judge is determining whether to believe what the claimant is saying and determining how injured and how disabling that injury is to the claimant. And the administrative law judge is the judge and the jury, so to speak, right?
That's absolutely right. He has to apply the law and determine the facts to apply
Meaning,
them.
meaning to determine whether or not to believe the claimant.
Right. If you think about it, you wouldn't need to have a hearing if you could just send in medical records and win the case. They need to hear how it affects that individual claimant.
So it's not enough that you are injured. You have to show that your injury when you apply for SSI and SSD is disabling.
That's right. And my friend, the administrative law judge, talked about some of the things that he's seen over the years that affect his ability to believe the testimony.
Okay. The first thing is when when a judge will ask, what is it that you are able to do? And a typical answer, and I hear it here in the office all the time: I can do anything. I can do nothing.
Right.
Right?
Right.
Well,
And we know that's not true because they're sitting in front of you. How did they get there? Right.
exactly. Exactly.
So it's important to be specific and indicate when a judge asks an open question like that. What can you do? Well, in the morning, I'm able to wake up, but I have a hard time preparing breakfast because I can't stand too long. Or I have a hard time doing my morning bathroom routine because I need support to stand in the shower. These kind of examples are much better than just saying, I can't do anything.
Okay. So there is no such thing as I can't do anything. You can always do something, and you need to be specific. I can do this, I cannot do that because of the injury. I can do this, I cannot do that. I can do this, but I can do it less often because it hurts me. And that is far more believable than saying
Absolutely.
do anything, because that's not true.
Absolutely. And another example that I hear often from my disabled clients is, I'm able to push a vacuum cleaner in one room, but after I do that, I'm so tired I have to rest for 20 minutes before I can vacuum the next room. These are concrete examples that show how their functional ability is impaired by their disability.
Mhm. Another thing that the administrative law judge uh, brought up is when he asks claimants, what's your pain level like on a scale of 0 to 10, 0 being no pain and 10 being extreme pain, and the answer is 11.
Right. And that's ridiculous because if it was 11, they wouldn't be able to speak. Okay. Usually the scale is 0, I have no pain at all. A number 10 is take me to the emergency room. Okay. So if you say when you're sitting in a hearing that it's a pain level of 10, well, that's just not believable. And the judge is immediately going to start to think, well, what else is this guy or woman saying that might not be true?
The administrative law judge is like a family law judge. The family law judge in divorce court, custody court, is the judge and the jury.
Right.
So you have one person to convince of your believability, of your credibility. The same when you appeal your denied SSI or SSD claim. Another thing that your friend, the administrative law judge, sees is when he sees as evidence of lack of believability and credibility is when he asks the question of the claimant, can they lift anything? And the answer is, I cannot lift anything. And I love the one thing you told me is, he once asked a woman, or you use the example of a woman, can you lift anything? I cannot lift anything, but she's carrying a large bag that probably weighs 15 pounds. You know how us women, we carry these big bags that looks like we are traveling, but really they're fashion.
Right. And then, hopefully we'll be back in person hearings relatively soon. And when hearings are in person, uh, the person actually walks into the hearing office or into what, is a courtroom. And if they're walking in carrying the bag, they may not be on the record just then, but the judge sees that. He sees that behavior and he knows that when this person next says that they can't lift anything, Well, in fact, they walked in a minute ago swinging a purse that looked like it did have some serious weight to it.
The problem with lying is once a judge, let's say, in this case it's a judge, once the judge catches somebody in one lie, I think it blinds the judge as to the believability of any other question and answer, because now the judge is wondering, she or he lied on this, what else is she lying on? So maybe the person lies on one thing and then tells the truth on the rest, but you've already prejudiced the judge against you because you already caught into a lie. So it's almost like you don't get a second chance. He's already concluded that you are not to be believed.
Right. My friend, the judge, said, he summed it up by saying, hey, judges are human and they're going to apply their life experiences to what they see in the courtroom, and they're going to react to things the way anybody else would when they hear about it. So that's what you need to keep in mind.
And whereas they may have a poker face on the outside, a lot is going on inside their brain. They're drawing their own conclusions based on the body language and based on the believability of the answers and drawing from their own life experience. So you might look at the judge and not see necessarily a reaction, but it's going on inside in their brain.
Right. And then you'll see it in the decision.
And then exactly. And then you will really discover what this judge thought of you when you get denied.
Right. And the way to overcome that is to have really good medical evidence to support your testimony, and to have your testimony be believable and match the findings in the medical evidence.
Correct. And the last thing that he did talk about, and by the way, you go over all these things with your clients as you prepare them for a hearing. But there's one thing that you cannot go over. It's too late to go over it as you prepare them for the hearing. Is something they needed to have done and continue to have done throughout, which is treatment. Like if you don't treat, or if you stop treating, then if you don't treat, then there is no evidence of your injury. What are you doing asking for SSI or SSD? And if you treated and stopped treating, well, then maybe you're all better now. So the treatment, the need for treatment and the need for the continuity of treatment, obviously, if you need it, we're assuming that if you're applying for SSD, that means that today you have an injury that you believe is disabling you and preventing you from finding work. So we assume that means that you are hurt. Therefore, you need continued treatment. Can you talk about the treatment, one? And what if somebody treats, but then 9 months ago was the last time they saw a doctor? How does that adversely affect their case?
Sure, Joumana. And I've seen this a lot over the last year because of the pandemic. A lot of people either couldn't get to see a doctor, or they were afraid, justifiably so, to go to a hospital for their treatment. But the fact is, if you've got a condition that's serious enough that it prevents you from performing your work functions, it better have a fair amount of doctor's treatment to back it up. I've got clients, for instance, who have an epileptic disorder, and people with seizure disorders often will have a seizure and they know how to deal with it, and they do it and they handle it themselves. But if I go into a hearing and I tell a judge that they're having seizures twice a week, and there's no doctor's visits, no emergency room visits to back that up, that's going to be really hard to prove. So that's an example of if you don't make a record of it in a health professional setting, you're not going to be able to win when it comes time for the hearing. Now, when you talk about recent treatment, the problem with that is if I've got a doctor's note that has restrictions, physical restrictions on my client from last June, and I'm trying to prove that they're still disabled, how am I going to do that if they haven't been back to the doctor? We need to have those updated, certainly on a month or every other month basis when they see the doctor.
Correct. And we've seen this in car accidents, like you've seen it in workman's compensation. Those who were previously injured, and then we went through COVID with all the lockdowns. Yes, I mean, a judge will understand that your client who is not in acute distress couldn't treat in April of last year when everything was shut down, didn't want to treat even in July of last year and August because we had just reopened and there was still a lot of fear about COVID and how you catch COVID and where you catch COVID from. And he did not want to go into medical facilities where there are a lot of patients. And to this day, clients continue to tell me this. And I mean, it's legitimate. This is a very legitimate concern. Some people are so cautious that they're working from home and they're insisted, no matter what the laws are out there or what the rules imposed on them, they want to work from home because they're still concerned about catching it. So, yes, I mean, an administrative law judge will be understanding during that time period, but the further away we go from that, the more difficult it will be to convince a judge that I have not treated for a year and a half because of COVID. And with the advent of telemedicine, where most doctors will accommodate Zoom doctor meetings, you have that available.
Well, absolutely. I mean, doctors have to pay their bills too. So they had to adapt when the pandemic happened. And even though it might not be as good an exam you get over a telephone or video exam, the doctor's still going to provide that because they have to pay their bills.
Now, physical therapy, chiropractic care, you cannot do that by Zoom, obviously.
That's right.
So it's a difficult situation, but it's going to become increasingly more difficult to tell an insurance company, whether it's a car insurance company or a workman's comp insurance company, that you have all this time, no treatment, and yet you're injured. You may be injured, but if you went for a year of no treatment because of COVID, the argument is going to be, you're injured, but clearly you're not that injured, because if you were that injured, you will be screaming of pain and running to seek some treatment here or there. So it becomes increasingly hard.
I agree.
Let's take a quick break. And as soon as we return, we are going to talk about COVID on the job, catching COVID either on the job or catching COVID from outside the job and bringing in the job. And we're talking about it within the context of, is this a work-related injury for which you can get your medical bills paid and your wages paid by the workman's compensation insurance for your employers? Yes or no?
هل لديك مشاكل في قضايا الضمان الاجتماعي أو قانون إصابات العمل؟ المحامي باتريك هوران من مكاتب المحامية جومانا كيروز يضع خبرة 28 عاما في قضايا الضمان الاجتماعي وإصابات ضمن العمل في خدمتكم. الاستشارات مجانية. اتصل الآن بمكاتب المحامية جومانا كيروز 248-557-3645. يتحدثون لغتكم العربية والكلدانية 248-557-3645. قد يحاول بعض المصابين في حوادث السيارات إدارة قضاياهم توفيرا لأتعاب المحامين، والآن مكتب المحامية جومانا كيروز بإمكانه المساعدة من خلال إشرافه على سير القضية في جزئها الأول المتعلق بتعويضات الراتب والخدمات المنزلية، وتقوم بإرشادك في كيفية إدارة ملفك مجانا، بينما سيتولى المكتب مهمة الدفاع عن قضيتك في جزئها الثاني المتعلق برفع دعوى عن عطل وضرر. للمزيد من المعلومات اتصلوا بمكتب المحامية جومانا كيروز والاستشارات مجانية 248-557-3645. مكتب المحامية جومانا كيروز يبحث عن موظف أو موظفة يجيد اللغتين العربية والإنجليزية بطلاقة، والخبرة غير ضرورية. الوظيفة بدوام كامل 5 أيام في الأسبوع. للراغبين بشغل هذه الوظيفة الاتصال بمكتب المحامية جومانا كيروز على رقم 248-557-3645 248-557-3645. Your Rights مع المحامية جومانا كيروز. عودة إلى برنامج Your Rights مع المحامية جومانا كيروز. أرقام الهواتف في الاستوديو 313-769-6666 519-256-1023. تحياتنا لكم جميعا. جومانا، في عندنا سؤال تحت الهواء عن الوظائف في المكتب. هل ذكرنا في الإعلان أنه هي هناك يعني وظائف بدوام كامل أو دوام جزئي part time full time، لكن هل هناك benefits أو يعني إذا تعطينا معلومات عن المخصصات المتعلقة بهذه الوظائف؟
نعم طبعا there are benefits اللي بيحتاج من health insurance, vacation time, paid time, it's دوام full time. Let me see if I missed anything else. No, I think that's yeah, absolutely. وواحدة من البوزيشنز على فكرة هي for our immigration department. يعني يمكن حدا من المستمعين بيهمه موضوع الهجرة والتجنس. For one of the positions that we are still looking for, we did a lot of interviews, but we're still looking for, لأنه المحامي has a lot of training to do. It's not, you cannot train somebody in a day or a week or a month. So بدنا نكون حذرين بالاختيار الصح قد المستطاع من البداية. نعم.
إن شاء الله نتمنى التوفيق للكل أكيد، واللي حابين أكيد يتعرفوا على مزيد من التفاصيل حول هذه الوظائف بإمكانهم الاتصال بمكتب المحامية جمانة كيروز 248-557-3645. جمانة نرجع لك.
شكرا رامي. رح أقولها بالعربي قبل ما نطرحها بالإنجليزي. حكمت الولاية من 6 أشهر وجمعة بأكتوبر 2020 بأكتوبر 16 2020 طلعت بريس ريليس للأشخاص اللي بيلقطوا الكوفيد وهن بمهن معينة. لهؤلاء الأشخاص وهؤلاء الأشخاص فقط إذا لقطوا كوفيد بيقول البريس ريليس رح نعدل القانون ورح نعتبر إنه لقطوا هذا الكوفيد on the job، يعني هي work related injury، ومن وراها بحق لهم يتعالجوا ويحصلوا على الراتب تبعهم من الوركمنز كومبنسيشن تبع الامبلوير. نعطي مثل، موكل من موكلينا بيشتغل لبومونت هوسبيتال وما بنعرف لقط الكوفيد، ما بنعرف إذا لقطوا ببومونت ولا جابوا لبومونت. we don't know which one it is. ابتداء من 16 أكتوبر سنة الماضي بتقول حاكمة الولاية لأنه هو من فئة معينة من العالم، وبالتحديد اللي هن فرونت لاين وركرز، ورح نحدد أكثر مين الفرونت لاين وركرز. القانون تعدل، ما بقى نبحث لنشوف هل هو لقطها ببومونت ولا لقطها خارج بومونت. لا، إذا لقطها ببومونت بالفعل هي إصابة ضمن العمل، بالفعل الوركمنز كومبنسيشن انشورنس تبع بومونت لازم تدفع له طبابته والراتب تبعه، ولا هو لقطها من أصدقائه وهو جايبها على بومونت. رح نلغي هيدا الاناليسيس، رح نلغيها، ما رح ندخل فيها. رح نقول في presumption إنه حصل عليها on the job، يعني رح نعتبر بغض النظر إذا هو أخذها ببومونت ولا جابها لبومونت، كونه بيشتغل ببومونت front line worker health worker، رح نعتبرها إصابة ضمن العمل لحتى نساعد هيدا الإنسان ليحصل على طبابته وعلى راتبه. ومثل ما بتقول I'm quoting, these brave men and women have been on the front line of this pandemic, so بدنا نساعدهم. القانون اللي طلعته ب 16 أكتوبر هو فقط بيتطبق مش لشخص بمكتبه، مش لشخص بيشتغل بالراديو، هو فقط للأشخاص اللي هن health workers front line health workers. لهؤلاء الأشخاص ما رح ندخل بالسين والجين وين لقطوه كيف لقطوه، رح نعتبر it's a presumption إنه لقطوه on the job، يعني هي work related injury، يعني هي إصابة on the job، بحق له هذا الشخص إنه رب العمل تبعه الانشورنس تبع رب العمل تبعه تدفع له طبقته وتدفع له تقريبا لحد 70% من الراتب تبعه. تطبق فقط رامي and I'm gonna read them لا healthcare employees and first responders who have tested positive for COVID-19, specifically workers in the medical facility، يعني اللي بيشتغلوا عند الدكاترة مثلا، اللي بيشتغلوا urgent care مثلا، including hospitals, medical care facilities, emergency medical services، وبالإضافة law enforcement. محاميين are not law enforcement. law enforcement يعني البوليس، كمان law enforcement، وكمان fire safety، وزادت كلمة صغيرة لا تتركها مفتوحة and others ما بنعرف شو يعني. هؤلاء الموظفين إذا لقطوا كوفيد ما رح نسأل إذا لقطوها on the job ولا لا، بتكمل these employees are presumed eligible under the Workers' Disability Act. لأنه عادة رامي القانون بيقول إنه الإنسان اللي بيحصل على طبابة من رب العمل تبعه وراتب من رب العمل تبعه أو من الانشورنس تبع رب العمل تبعه لازم يثبت إنه الإصابة صارت on the job. But these are uncertain times. هؤلاء الأشخاص صنفتهم وحبت تكافيهم لأنه حطوا حالهم بالطليعة وما وقفوا شغلهم. نحن كلنا قعدنا بالبيت، بس المستشفيات، الدكاترة، البوليس، الامرجنسي روم، EMS ضلوا يشتغلوا ويقدموا. فكمكافأة لهم إذا لقطوا الكوفيد وما بنتساءل منين بنعطيهم workman's comp benefits. Attorney Patrick Horan, I took a little bit of time to talk about it in Arabic. Tell us about the press release issued by Governor Whitmer on October 16, 2020. And then let's move from that to say somebody, God forbid, an employee here in my office has COVID. Can we presume that he caught it on the job? And is it automatic that my employee will get workman's compensation and medical bills paid? So tell us what Governor Whitmer's press release says, and then let's apply it in a setting outside of healthcare workers and first responders like law enforcement and so forth.
Right. So this actually is a political battle that happened last year between the governor and the legislature here in Michigan. We've learned a lot about this pandemic over the course of the year, unfortunately. But a year ago, there was real fear on the part of workers who had to report to work in a dangerous situation that if they were going to come down with this COVID-19, how would they provide for their families if it prevented them from working? Ordinarily, we've talked a lot about Michigan workers' compensation cases. They're difficult to prove, and they can take a long time to prove. So the governor...
You have to show that they arise out of your employment.
That's right. And so Governor Whitmer issued an executive order way back in April that addressed that and said, no, for people who are in frontline workplaces, healthcare employees, first responders, people that our society needed to go into these, what at the time might have been seen as a very dangerous occupation with this pandemic, that they needed to be protected by the workers' compensation rules, and their claims should be streamlined so that they don't have to show causation. They just have to show disability. Those are the two the two required aspects of any workers' compensation case. You're disabled from your injury or disease, and it was caused by your employment. This presumption meant that you didn't have to show causation.
Let me clarify. You said in April. Did you mean in October?
Well, and that was kind of as historically, she did this last April. And then, if you remember, the legislature overturned or invalidated her powers to grant executive orders. And once that happened, she had to reissue them in October. And this is the current one is the one that I sent you, which is a press release in October of 2020. But it was done, it was taken away, and it was reissued. So she's been fighting to protect frontline workers both times.
And let's be clear here. If someone catches COVID on the job, like a frontline worker who works at Beaumont, and they're out of work, they may be out of work for an extended period of time. Yes, they can apply for unemployment. It's going to take a long time to get it. And guess what? Unemployment does not pay for their medical bills. So workman's comp is a much better choice than unemployment. Workman's comp pays your medical bills arising out of your treatment for COVID, as well as about 70% of your wages. Unemployment.
Don't forget, Joumana, that to get unemployment, you have to be ready, willing, and able to work. And if someone is sick enough from COVID that they can't work, they don't qualify for unemployment generally. They would qualify for either a short-term disability policy, a private disability policy, or for workers' comp if they contracted the COVID on the job, or if they are a frontline worker covered by the governor's proclamation.
You know what? Thank you for correcting me. You are 100% right, and I was 100% wrong. Unemployment is only for people who are physically ready, willing, and able. Once you get COVID, you're not physically able anymore. Once you're in a car accident, you're not physically able anymore. So you do not qualify for unemployment. You are so right. So in their case, in one of our clients' cases, Beaumont did not offer him workman's comp. They offered him short-term disability.
I couldn't believe it when I met this gentleman. He actually was an old client of mine that I had represented years ago for a different case. And he called me up. He's been off work since May of last year. He contracted COVID twice, documented at his employer at Beaumont and also at his private doctor's office. And he now has sequelae of the COVID that's preventing him from doing his job. And Beaumont offered him short-term disability until that ran out in November, and that's it.
And what he should have done is make a workman's comp claim, because that does not run out. I mean, they will continue treating you and paying you your wages until your retirement, kind of.
That's absolutely right. And many people, as we now know, the vast majority of people who contract COVID have short-term symptoms and thank goodness don't have a long-term disability from it. This particular gentleman has been diagnosed with viral myositis, which is doctors feel is related to the COVID that's preventing him from working going forward. And I don't know what his prognosis is. He may be off work for quite some time.
So whereas short-term disability is really short-term, something like 14 weeks, and then it kicks into long-term disability, which is another more weeks. It's limited, in other words. Anyhow, workman's compensation offers benefits for far longer.
Right, and it's likely to be more as on a dollar basis per week than any of those other policies too.
And what is your approach with Beaumont? What did you or what are you going to do about the fact that they did not make a workman's comp claim, but they offered him short term?
Well, I filed a workers' compensation claim with Lansing. In fact, the case has just come up for a pretrial in the last couple of weeks. And I alerted their attorney that this is what was going on, because I've had other cases with Beaumont over the years, and I knew who their lawyer would be. And he's investigating it. I'm sure he's having a discussion with their risk management people about how that should be handled in the future. And then he'll work this case up and defend it like they always do.
Okay, so then what we have established today is that if you have COVID, regardless of whether you caught it on the job or you brought it to the job, if you are a frontline worker, if you are in the healthcare industry, if you are in the law enforcement or fire safety and others, whatever that means, then we will presume that it is an injury you got on the job, regardless of whether you did get it on the job or not. And you can make a workman's comp claim and you can get your medical bills and your wages covered. So that's great. Now, what about outside? This press release, this order only applies to healthcare workers and frontline workers. What about the rest of us? What about somebody working?
The rest of us are in exactly the same situation with a COVID diagnosis as you'd be with any other injury or disability in workers' comp. You have to show that it's more likely than not that it was caused or significantly aggravated by the job. So that's difficult to do. Maybe with contact tracing, it wouldn't be that difficult. For instance, I'm thinking of a waitress in a restaurant and a customer came in who was sick, and it was proven by contact tracing that he or she was exposed to that customer. I would think that would be a case that you could overcome, that it was more likely than not caused by the job.
So in other words, everything else, if you have COVID You have to be able to show, if you want to go on workman's comp and get your medical bills and your wages paid, you have to show that it arose out of the job. You have to show a causal connection between the job and COVID. You have to show that you caught it on the job, and that's not an easy thing to do.
No, it's not. But I don't know. I have a feeling that most people who've come down with this disease, they've got a pretty good idea of where they caught it. And sometimes that's actually documented through contact tracing.
Can you tell us a little bit more about contact tracing?
Well, for instance, when for the longest time, you couldn't get a haircut. Do you remember that?
Yes.
And when my barbershop reopened, when I went in to get a haircut, he asked for our name and telephone number. And I said, well, why is that? He said, well, that way, if somebody does get sick, we'll be able to let everybody know who came in that day that they were exposed to that person. And so that's an example of contact tracing that's kind of low tech, but some places like old folks' homes have a high tech way of doing it by taking your temperature when you show up.
Mm. Okay, very good. Okay, so again, we want to clarify that the presumption is only as to first responders and healthcare workers. The rest of those who catch COVID, they have to prove, in order to make a workman's comp claim, that they got it on the job. You told me something I did not know before, that if somebody's out, I don't know, don't quote me on this, but I think that the CDC maybe now said if you have COVID, you only need to quarantine for 7 days, but I can be wrong. So at any rate, what you did say to me is that workman's compensation, if you are out for less than 1 week, for less than 5 work days, workman's compensation will not pay your wages. They'll pay your medical treatment, but they will not pay your wages.
That's right. With only one exception, can you get wage loss if you're out for less than a week?
Okay. What is that exception?
The exception is what's called a specific loss, where you have an amputation. If you have, for instance, lose a finger in a saw. I have a client who lost a finger in a saw, and if he goes back to work the next week, he still gets a certain specified number of weeks for that specific loss, that amputation.
Okay, very good. All right. Want to remind the listeners that we are talking with Attorney Patrick Horan, who specializes in Social Security, disability, and workman's compensation. The third subject that it looks like we're going to have time to talk about is, it's very easy when somebody gets injured on the job. You know when it happened, and you know how it happened, and one of your body parts is hurting. That's the easy one. The hard one is when you have what's called an occupational disease. Maybe you were exposed to fumes or something on the job, and there is no one point in time when you realize you have an injury or a disease. You go to the doctor, you have symptoms, you go to the doctor has her or his suspicions, asks you where you work and what you do, and often will be the one to tell you, we think you caught this on the job. This is a work related disease, and you can file workman's compensation for it, right?
That's right.
Can you tell us about the case that you have? The flight attendant, we will not say which airline, the flight attendant, the story of the flight attendant.
Yeah, Joumana, so I represent a flight attendant who was on a flight heading west, and people noticed a strange chemical smell in the cabin, and the pilots noticed it in the cockpit. And out of an abundance of caution, to their credit, they cut the flight short and landed, I want to say, in Las Vegas. and got everybody off of that plane. But she and other workers on that plane were exposed to what people are calling an aerotoxin, and it was fumes that were gassed into the cabin inappropriately from the jet fuel or from the hydraulic system in the plane. And it caused her really significant neurological problems. She has difficulty with concentration, memory, focus, and she's been off now for quite some time. The airline has denied it. It was a demonstrated occurrence. I mean, the fact that they had to land the plane, we know something happened. But it's a more difficult, typical flight attendant cases I had over the years where they hurt their shoulder reaching up to close the overhead bin because you have too much luggage up there.
Sure, that's the easy one. So back to the flight attendant. Are you saying that she got her neurological injuries from a one-time exposure, or are you saying her airplane has been emitting this on a regular basis, that every time she serves as a flight attendant, she's getting exposed, and it progressed enough that she developed those symptoms that you talked about, memory problems, lack of focus, and you also told me personality changes. And that's when the doctor became suspicious and they started piecing the piece of the puzzle together. But you're not saying it was a one-time exposure.
Well, I'm definitely in my claim, I'm focusing on the one exposure because it was really well documented. Now, she's going to tell me a different story, that there's been other times when she smelled things that it maybe have not been as serious. But there's two things going on. There's going to be an underlying cumulative exposure, like you're mentioning, and also this one acute exposure that really seemed to cause her the biggest problems.
You said to me that these progressive occupational disease cases, they're often picked up and discovered, or the cause for them, relating them to the job, to the workplace, are often discovered by the doctor.
Well, that's right, because like you mentioned at the beginning of this topic, if I hurt my hand in a press at work, well, I know exactly what happened and I know how that happened. But if I come home and begin vomiting or having symptoms that I maybe wouldn't link up to what happened on the job, and I go in and get a battery of testing from my doctor that shows that I've been exposed to chemicals, now all of a sudden I'm wondering where those chemicals were, right?
That is correct. That is correct. So it's easy when, you get a physical injury on the job, but then when you have all these symptoms outside of the job, and the last thing you're thinking is, was I exposed to something that is causing these symptoms?
Exactly.
You did say that immigrants, particularly, are often more exposed to these occupational disease cases than others, or to those occupational diseases, because a lot of us immigrants, we come here and we start from the bottom up. So we take factory jobs and jobs where production, where you're surrounded by a lot of chemicals and fumes.
I think that's true, and it's not fair, but I think it is true that people in on the bottom rung of the employment spectrum are going to be exposed to more dangerous jobs across the board, and that's going to be true of chemical exposure as well as dangerous occupations from moving machinery and so forth.
Okay, so some are easy, very easy to tie to the job, and some are subtle. And we wanted to talk about it today because we've been getting some of these calls.
Yes, Joumana, I've got a client who was exposed to black mold on the job, and she's got terrible lung conditions now that her doctors link up to that exposure to black mold.
And was she exposed to black mold for a consistent and long enough?
A long period of time, and it was documented as construction was done. She was working in a store, and the mold was behind freezer cabinets, I believe. And when they would pull those out and do maintenance on them, the mold was all documented that it had been there for years.
Yeah. You did say that every workplace, whether it's an office or whether it's a factory, is supposed to put a chart on the wall or offer it to you if you ask for it of the material you are working in or the chemicals or the fumes or whatever that you are working in when you are working, correct?
Right. And those are called MSDSs, Material Safety Data Sheets.
Mm-hmm.
And that's the first thing that I'll ask for when I file one of these claims. I'll subpoena the employment records and the MSDSs to determine what exposures my client might have been exposed to.
Okay, so that sheet, that material safety data sheet, will list to the employee what what is it, fumes, or how would you call it, what material?
Yeah, chemicals. As an example, I had a client who worked in an automotive body shop. Okay, and the MSDS isn't going to say it's XYZ paint. It's going to say paint containing toluene, acetone, all the different chemicals that might have been in the paint that he used.
Mm. I'm thinking of nail salons, and the amount. Well, serious, the continuous amount of exposure to people who work in that field.
Joumana, I should not laugh. You're absolutely right. And think about it, their face is right next to the chemical.
That is correct. However, people in nail salons have always put masks on. And I've always kind of thought it's because of the fine dust, because as they're like, turning things into fine granules. Do you think these masks, and I'm just asking not as an expert, obviously, but as a layperson, do you think these masks are sufficient to protect workers, whether it's in a salon or in a factory, against chemicals, against gases?
Well, that's going to depend on each individual exposure. And I know that OSHA has requirements in an industrial setting for specific type of masks and or respirators, or even what are called fresh air respirators, where you've got a hose that's giving you air to the mask. Right.
And OSHA stands for Occupational Safety and Health Administration. And that's that's federal law that is enacted for the protection of all workers, for the safety of all workers.
That's right. And there's also a MyOSHA, which is the Michigan branch of it.
And then there is the federal branch.
Right.
Okay. So today we have about 4 minutes remaining. Today we talked about things we have not really talked about at great length before. We talked about the presumption of having COVID on the job if you are a frontline worker or if you are in the health industry, pursuant to an order enacted by Governor Whitmer. However, if you have COVID and you work in a private setting that does not include, maybe private is not the right word, but in a work setting that is not healthcare or first responder setting, then you'd have to prove that you got it on the job for you to get workman's comp. We talked about some, they're not injuries, they're diseases that are related to the job, that arise out of the job, that are far more subtle to you because you're miles away from thinking it's caused by what you're smelling and getting exposed to on the job, and often will be picked up by your doctor, but they will be related to your job, some occupational diseases, versus the clean, easy, work-related case. By the way, with less than 3 minutes remaining, can we remind the listeners again that even in workman's compensation cases, a workman's compensation insurance has the right to request what they call, it's not true, but what they call an independent medical examination, or IME, and that pursuant to the terms of your policy, you must submit to it. We've had a number of people who not relocated, but are out of the country for an extended period of time, what is their duty as far as submitting? Can they say, well, let's cancel it because we're not in Michigan or we're not in the States? Let's reschedule it. And can't you have your case dismissed if you ultimately fail to cooperate with your insurance company in submitting to an independent medical examination?
So those are interesting questions. You definitely have a duty to comply with an independent medical exam scheduled by your employer or their insurance company. Ordinarily, if you've moved, they will set up an exam at your new place
State.
of residence.
Right.
However, if you're overseas, I'm not sure how they would handle that. One thing we talked about a minute ago was the new advancements in telehealth, and I think you could probably do an IME through a Zoom video if you had to.
Well, that is a first for me. I've not heard yet, at least in the context of car accidents, of an IME by phone, because the IME, part of the IME requires a physical examination, stands. And so I don't know how easy it is to conduct it via Zoom. Have you heard of a Zoom IME?
I have not, but I do know often when my clients move out of state, the first thing the insurance company will do will be to hire an expert to do a records review and try to write a medical opinion regarding the client's condition based on their review of the treating records. So that's one way they get around it.
And very quickly, because we're down to the last minute, very quickly, if someone's out of the country, what do you advise them? Come back so that you can do your IME?
I think I would, because we want to make sure that they're entitled to benefits, and the defendant will definitely file a motion to suspend benefits if they can't get that examination done.
And I will tell you, in the context of a car accident, I've seen it happen. The defense will file a motion to dismiss the case for the plaintiff's failure to cooperate with the insurance company. Attorney Patrick Horan, some amazing and new information today that we've heard for the first time. Thank you so very much. And thank you to all of our listeners. Rami, thank you so much. Tomorrow, we will be talking about bankruptcy law with Attorney Michael Bengstein. Thank you.
My pleasure, Joumana.